Yeah, so we're going to talk about the Ndps Act itself and its applicability to cases which have arisen over a period of time, mostly at the prohibited areas, wherein a lot of import and export takes place. Today, we're going to discuss principally about two matters where the accused persons have been caught at the airport. Now, as you all know, our airports are very sensitive areas, the airports, the seaports, and they are also areas where a lot of clandestine activities, smuggling takes place. We have a security in place, but in spite of that, there are these masterminds who are keen in trying to smuggle out contraband in whichever way possible. Of late, you must have heard the number of seizures that have been made where heroin has been attempted to bring into our country through the ports in Gujarat. And therefore, it is important for us to first understand what are the safeguards that are in place at these prohibited areas, our security areas. And thereafter, the modus operandi of most of these accused persons who try to either bring in the contraband or take it out of the country. Now, we all know about the Ndps Act, I'm sure, and I'll just give you a brief outline of what the Act is, and then we'll talk about these cases. Now, it's any special act which is enacted by Parliament will have a defining clause, will have a prohibitory clause, will have a special class of officers who are empowered to investigate under that special statute. And thereafter, we have the punishing sections. Now, as we know, there was a notification in the year 2001 which classifies the weight of the contraband, and in respect of which it would attract a corresponding sentence. So there is a small quantity, intermediate quantity, and we have what is known as the commercial quantity. Now, these two cases which I would discuss with you today are one is in respect of a very famous table tennis player who also represented our country at international level. He was a national champion, and he was lured by certain Nigerians to make a trip to Nigeria. What he was told was that there is a table tennis tournament there and that he had to play there as a professional. Now, what they told him was that every expense was paid for, he was going to be taken care of there. And he was about 19 years old when he was arrested. I mean, his name is Lalrin Puya, and I do not know if you guys have heard about this particular boy. As I said, he was just 19 when he was arrested. Comes from a decent background, educated, went to college, went to school. But throughout my career and all these years, what I have realized is that, especially while traveling, I do not take baggages, purses, or gifts from any unknown person. Be it your best friend, there is a good chance that there would be something inside it which even you are not told about and you are carrying. Now, the reason why we chose this as the first to be discussed in the first lecture is that when you talk about import and export, the moot question that arises in these cases is possession. And that is a very vital aspect for an offense under the Ndps Act, and the charge in respect of which is to be proved by the prosecution in court. Now, when you talk of possession, it has a very wide meaning. It has a number of ramifications. It could be constructive possession. It could be physical possession. It could be something that is remote controlled. You'll be shocked at the amount of cases that we have represented in court where kids, when I say kids, is 19-year-old, 18-year-old, 17-year-olds who have been told that kindly just give us your KYC documents. There is some parcel that needs to be sent. Kindly just take this bag, or you're traveling abroad. I have a cousin there. He needs this urgently. It may be in the form of medicines. And there is one very vital aspect which during the course of our interaction, I will try and point out to you is the psychotropic substances. If you see the list of psychotropic substances, most of them are substances which are also covered under the Drugs and Cosmetics Act. And they are available very easily in the pharmacies. For example, Corex bottles, and very recently, tramadol that has been introduced in the NDPS Act. I mean, tramadol strips are available at any pharmacy for 6 rupees. 6 rupees for 10 tablets. But little do you realize that if you try and attempt to carry about 15 of those strips, you're going to land into deep trouble. Now, it may happen that medicines are expensive abroad and you are given a package, kindly give it to, my friend so-and-so. And unerringly, you are caught at the airport, and when a question is asked to you that whose packet is this, you're going to say, sir, it's a friend's packet. I am supposed to only deliver it to somebody. Now, the moment you accept possession under the NDPS Act, there is a presumption against you. The law presumes that you had knowledge. It is up to you to lead evidence only at the time of trial to rebut that presumption. So at the initial stage of investigation, if you are caught with any kind of contraband, it is curtains for you. And if that contraband is commercial quantity, you are looking at a very long time in jail. Now, these two matters, the reason why we took it up for discussion today is both these cases, both these accused persons who are in jail, at least one of them is out, Lalin Priya was acquitted. But Shahbaz is still in jail in view of the fact that he did not know what he was carrying. He was given a packet and he was told, kindly just deliver it to one of our friends abroad. And what resulted was a recovery of 2 kgs of charas from that particular packet. As far as Lalin Priya is concerned, as I said, he was a table tennis player. He was taken there for the purposes of trying to be, projected there as an international player and to promote table tennis. They took him there. He stayed there for about 15 days. And on the way back, a bag was handed over to him. And it was told that just take it back. You're going back to India. This is one of our friends will collect it. As I said, he was 19-year-old. He didn't know the repercussions of what he was carrying. Obviously, I do not even know whether he knew at that point of time what is the repercussion of being found in possession of contraband. When the boy landed at the airport on the 13th of December 17, the NCB were already informed about the fact that he was to come at the airport. Now, under the NDPS Act, you see this information which is received by the investigating agencies assumes importance in view of the fact that there is a mandatory provision under the law which requires them to reduce the information into writing. When we discuss about information section 42, I will come to that aspect. But when you talk of cases which are made on information, there are 2 types. One is which is based on a specific information, and one is a chance recovery. The moment the recovery is on the basis of an information, the officers are required to reduce their information into writing and submit to their superior officers. But we will not deal with that today. The fact is that this boy landed at the airport and somebody at some end had already informed the NCB that there was contraband in his bag. Now, the route that he chose to take, obviously it was arranged for by the persons who had taken him abroad. He had taken the flight from Addis Ababa to Mumbai. Now, there are 2 flights from Addis Ababa to Mumbai on a daily basis. Flight 610 and the other flight is 640. 610 lands at about 4 o'clock in the morning, and 640, ET 640 lands at about 10 in the morning. Now, what happened was that when he took off from Addis Ababa, one of the flights on which he was booked, that is 640, the airline decided to cancel that flight in view of the fact that there was a very light load on the flight. Now, he checked in his baggage for flight 610. When he checked in his baggage for flight 610, he was told that you are already booked on 640. So therefore, they checked him in on flight 640, but thereafter they canceled the flight. So the baggage tag, which was attached on his bag, bore flight 610, which was to land at 6:10 in the morning at about 2 o'clock. And 6:40 was to land in the morning. Now the boy lands into the, he lands in India, and thereafter, post clearance of immigration, the NCB intercepted him. And they asked for his baggage, which he had obviously a claim tag to claim his checked-in bag. Now there is a particular procedure when you see, as a lawyer, over a period of time, what you realize is that the onus is always on the prosecution to prove its case. And in a given case where they rely on documents to prove their case, it is very important for them to prove contents of those documents as per the Evidence Act. If you see the Evidence Act and you see section 61 onwards, 61 to 65, there are the particular section of how a document has to be proved, primary evidence, secondary evidence, and so on. Now, in this particular case, the baggage tag, which was found on the bag, bore his name, bore his the baggage identification tag and the number. It corresponded with his claim tag. So obviously there was a prima facie case that was made out that this bag belonged to him. Search of the bag at the airport resulted in about 4 kgs of contraband, which in the drug identification kit, which most of the enforcement agencies have, was about 4 kilos. They tested it positive for methaqualone. Now, methaqualone is also a substance which is covered under the Drugs and Cosmetics Act at some point of time. Thereafter, there is some discrepancy there, but I'll come to that later. So the drug identification kit pointed that out to be methaqualone. Contraband was commercial quantity. This boy was placed under arrest. Now, when he was questioned by the officers, now this is important, you see, when we come to possession. He said, "Sir, yes, this bag is mine. Prima facie court case has been made out, but I am a table tennis player. I was invited by people there to play table tennis, and it was some exhibition matches that I played for, which were promoted there commercially. No, commercially, I do not know. But as far as I am concerned, I was offered a free ticket. I was offered from sightseeing. There was some enjoyment that was promised to him there. He fell for it. He comes back to India, shocked when he lands 4 kgs of methaqualone from his bag. The first remand application, which is filed by the central investigating agencies, is that they don't file FIRs because they are not police officers. So in the remand applications, most of the time, the remands are very cryptic. They will just write that there was a bag, it belonged to him. We have prima facie evidence to show that this man was found in possession. Now, the question here is twofold. Firstly, if the bag is on the conveyor belt, can you be said to be in possession of that bag? Secondly, the moment you pick up that bag from the conveyor belt, you automatically have physical control, you have physical possession of the bag. But till the bag is on the conveyor belt, question is, apply your minds to it, whether you can still be termed to be as somebody who is in possession of that bag. I have not picked up that bag. The bag is in the custody of the airline. Now, whenever there is an international travel, there is a number of factors that are attached to a particular bag which you check in. It has to be X-rayed. It is cleared by the security system at the airport. And the movement of that bag is always documented in the form of barcodes that are on the baggage tags. If you see, each and every airline on the baggage identification tags has a barcode. There is a specific purpose for that barcode. The movement of that bag, the moment you place it at the check-in counter, from the check-in counter, when it goes to the conveyor belt, it goes to the makeup area below, and then those bags are sorted out. So each and every bag that goes into those trolleys that are ultimately uploaded on the aircraft, there is a barcode that is scanned, which is kept by the loaders there. Post the loading of those baggages, that entire data, which is in the form of the barcodes that are uploaded in the website and in the system of the airline, is uploaded on the system. And most of these airlines have a system which is worldwide. Now you see, each airline has, we have thousands of flights, we have thousands of baggages. So I'm sure each time you wonder how they do it, you see, because each airport handles a few thousands of bags, I think would be more than that. So how is all this handled? And if you ever lost a bag at the air while traveling, you would know the repercussions and the trouble that a person goes through if your bag doesn't come out ultimately at your destination. So they are all documented, and each time this particular baggage moves from spot A to B, which are termed as designated areas, you have it uploaded on the system. Now, the time the bag is uploaded in the aircraft, when it is kept in the aircraft, is also documented, because as we all know, weight of a bag when you're traveling internationally is of prime importance. You are charged even for 3 kilos, 4 kilos. And that reason is, of course, it increases the weight of the aircraft, therefore fuel consumption, so on and so forth. But what is important for the purposes of ascertaining possession is that what time was the bag loaded in this aircraft? Was it loaded in the aircraft? Was it deplaned when it landed? And what were the tags which were on the bag? Where did they originate, and who is the author of those tags? Now, you see, it is impossible for any of the Indian investigating agencies to record statement of somebody who's sitting in Addis Ababa. The tags for a person who lands into the country, the author is the airline. It is issued at the place where the person has boarded the aircraft. And by the time it lands in Mumbai, that particular suitcase is in the custody of the aircraft. Now, in the movies, normally you see that there are people sometimes who put things in the bag. I mean, therefore, each time we travel, we say, don't leave your bag open. Somebody at the airport can put something in it. And it happens. There are cases where you see airport staff has been arrested for clandestinely trying to choose out routes. They choose their victims. They will see certain either elderly persons who are traveling alone, who are a little naive, or they find, teenagers who are gullible to some sweet talk and, try and either put it in some open. I have personally handled cases of such nature. And the people who are apprehended in such cases, it's very traumatic. But the question is about the possession. So when the bag came to India, you see, he picked up that particular bag. Now, the moment he picked up that particular bag from the conveyor belt, it was not necessary for the prosecution to prove any of the aspects in respect of possession, in view of the fact that the man was found in possession of that particular bag. Now, in a given case, you see, we have cases which are made in these prohibited areas where your bags, your goods are bound to you on the basis of documents. And there are cases which are made in town where contraband could be found in your pocket. You could be holding it in your hand. But in cases where the department tries to tie you up on the basis of documents, it is very necessary for them to prove nexus between the bag, the document, and the connecting link with you. That is in the form, if you're coming by plane, if you're, for example, importing something, it could be your airway bill. It could be your shipping documents. It could be a bill of lading. It could be your shipping agent. It could be all those documents that connect you with this particular contraband when you call for import or export. So when he was apprehended there and we saw the baggage tag, as everybody, each enforcement agency has to draw a panchnama. Now the boy landed at 2:10 in the morning, but the tag that was put was for the flight that was to come in the morning at 7 o'clock. You see, we had this documented in the panchnama at the stage of bail. We tried to convince the court, sir, flight lands at 2 o'clock. Baggage tag is 614640, which lands at 7 o'clock. It's not possible. How can this be done at this particular stage where the documentation itself falsify the fact that it is not on the flight which he came by? But unfortunately for him, he had two boarding cards, 1610 and 1640. The reason why he had two boarding cards was because the airline at the last minute had cancelled the second flight. But that was his saving grace during the course of the trial. Because during the course of the trial, the officer was more than happy to make out a prima facie case by pointing out, sir, I have a tag which points out his name. He picked up that particular bag, and therefore, at this particular point of time, I have a prima facie case. We traveled right up to the Supreme Court. In the Supreme Court also, the court was of the view, yes, prima facie, it appears that there may be some discrepancy in the case of the prosecution, but it is not sufficient for us to come to the conclusion that he has not committed an offense. You see, under the NDPS Act, we have section 37, which bars a person from being released on bail. And it's a twin condition, it's a non-obstant clause. So therefore, most of the people who are caught with commercial quantities are denied bail. So when the matter was being argued in the Supreme Court, the courts also opined, yes, you have a very good case, apparently on the face of it, but there is an explanation which the prosecution can give. The officer can step into the box and point out this particular discrepancy. Now, when the charge was framed, when I was reading the papers, I knew one thing. I said, if the officer decides to give an explanation, even till a judgment is pronounced, the prosecution has the powers to record the statement or examine any witness they choose so. And what I was dreading it, if they examine somebody from the airlines who comes and deposes that, sir, this flight was cancelled at that particular point of time, and therefore there is a mix-up in respect of the tags, then I would have had a task on my hand. But in such a case, what happens is that you cross-examine the airline officials on the basis of all this material that I have just explained to you in respect of the boarding card, the barcodes, and the movement of the particular bag. Now, what happens is, if you notice, there are a number of systems which different international airlines use. And each of these bags, a tag which is issued in respect of a particular number, the parlance is the moment the flight takes off till the time it lands, those tags are termed as alive tags. You see, the moment the flight lands, baggage is cleared, they'll give you a time gap of about, I think, 4 hours to lodge a complaint, missing complaint. If there is no complaint, then the system automatically shuts it as the bag has been delivered. But in most of these cases, the airlines who keep this kind of data available is for a limited period. So from my experience, I knew that he was arrested in 17. The trial started in 21. In 21, obviously, the airlines would not have that data that was initially available to them, and the NCB had not collected that particular data. So when the officer stepped into the box and he deposed in respect of what was recovered from this particular bag, the tags were pointed out as evidence. He submitted those documents into the court. My claim tag was submitted. What was argued is, sir, this is enough. There is absolutely no need for us to bring out any other evidence in respect of trying to prove the charge and possession. And at that particular point of time, you see, as a lawyer, over a period of time, you realize what you need to ask, what you need not ask a witness at any given particular point of time. What I realized was that there was no explanation that he had given in respect of the number of the difference in the flight numbers on the tags that he claimed I traveled on, and the flight number that was on the tag. So I did not ask him a single question in that respect. The moment I probed him on that count, he would have been alive to that situation. Yes, there is some difference over here, and I need to cover it up. So the entire matter, they conducted the matter on the premise that yes, we have the tags, we have the evidence. There is no need for us to give any explanation. During the course of the arguments, final arguments, when I pointed out to the court that, sir, this is a matter where I need not cross-examine any witness. The ticket shows that I traveled at a particular flight. Your Panchanama shows I traveled in respect of flight number 610. The tag is of a different flight number. So obviously this bag could not have landed at this particular point of time. And the reason you can take a defense of such nature is because of the fact that it was at the airport. So my defense was, sir, I landed, I had a bag, but this is not my bag. This bag has been foisted upon me. Now, normally, most of the time, the court say, why you? Why would the police or the NCB or anybody implicate you apart from all the people, thousands of people who travel? Now, in that respect, there is just one aspect that one needs it is for the prosecution to prove their case. It is not for me to defend myself or prove my innocence. So that is the cardinal principle of criminal law. So in such a situation, had I cross-examined that particular witness in detail in respect of the difference in tag, I would have brought upon myself evidence which would have been damaging ultimately to my case. The court kept asking the prosecution, how can you have a case where he has landed at 3 o'clock in the morning, your Panchnama starts at 3, ends at 5 o'clock, and the flight for which he is supposed to come on comes in the morning at 7 o'clock. But till the entire course of the trial, this aspect did not occur to the officer for whatever reason. As I said, each client comes with his own destiny. The amount of years that you have to spend in jail or the days that you have to spend in jail are, I believe, at some point of time, your own karma. We've seen miracles in court, cases which are on paper appear to be so tight. People get acquitted in view of the fact that the officer has used the wrong seal. And there are cases where there may be no evidence and people get convicted. Now, in a case, the reason why I find this matter very interesting is this. The boy came there. He had possession of that particular bag. From the bag, there was contraband that was recovered. And therefore, the question that one ought to put to oneself is this. Was it necessary for the prosecution to rely on those baggage tags? Or was it a clear case of possession the moment he holds it in his hand? Supposing the checked-in bag did not have tags. Thereafter, the onus of the prosecution would have been lessened. Why? Because their case ought to have simply been, sir, we caught this man with that bag. He may have torn the tags and thrown it out. He may not have a claim tag on him. Once the bag is in his physical possession, you do not have to have a baggage claim tag or a baggage identification tag on your bag. But in a given case, as is this particular case, they chose to rely on the baggage identification tag to connect me with that particular bag. And that is where their fallacy was. And that was the only advantage that I took during the course of the trial to try and convince the court that this bag could not belong to me. The reason being that the airport, there are a number of unclaimed baggages. Supposing you are caught, say, for example, on the street, I could not have said, sir, okay, there are a number of baggages there and it's a case of misidentity and this is not my bag. But because it was the airport where there are hundreds and thousands of bags which come in on each flight, this defense could have been taken. Ultimately, the court did find favor and acquitted this boy after a period of almost 5 years. But 5 years he spent in jail only because he took the liberty of trying to get a free trip to Africa. He had no knowledge that there was contraband in the bag. He had no knowledge and inkling of the fact that he was carrying 4 kgs of contraband, and he spent 4 years in jail. But the moot question here is this. The reason why we discuss the cases at the airport at the outset is because the airport cases, you see, there is very little scope of error for the defense. You have to admit your possession. You have to admit your presence at the airport in view of the overwhelming documentary evidence which is there to show that you were at the airport. There is a flight ticket. There are baggage tags. There are stamps which show that you have cleared immigration. So therefore, the defense is very limited. And the moment you try and prejudice the court by saying that it's a completely false case and deny your presence, a judge is not going to accept it. So therefore, the airport cases in particular, where there are documents available with the department to prove their charge, and there may be some material available with you to show that the particular article is not yours, that one aspect has to be exploited by you during the course of the trial to its maximum. You see, whenever you're going to trial, what you need to understand is this. You see the list of witnesses. Now, over a period of years, you know the officers, you know their capability, you know their intelligence, because at some point of time, you have interacted with them. From the list of witnesses who are going to be examined, you choose the weakest link and exploit it to the maximum. For example, if you see, and in most of the central investigating agencies, you have the superintendents who are seasoned officers. You have intelligence officers who are very well trained in procedural aspects. And you have most of the officers, of course, know you. and they know your line of cross-examination. But each matter needs to be handled on its own merits. And the weakest chain in as far as this case was concerned was the IO himself. He was new. He was a junior officer at that particular point of time. He did not know how to draw the Panchnama. He did not apply his mind to the fact that there was a discrepancy in the flight that he had taken and the number on the baggage claim tag. So for him, he was happy with the fact that I was found in possession. But the mistake that he made was this. He relied upon those tags in the court for the purposes of trying to prove possession. He did not rely upon the fact that, sir, when I found this particular person, the bag was in his hand. And therefore, at that particular point of time, when his reliance was on the baggage claim tag and the identification tag, for which there was a mismatch, that is what the court found favor with and acquitted this particular person. There is another matter which is at this particular point of time going on is Syed Shahbaz versus Union of India. And this is also a matter where the accused, when he was arrested, was about 19 years old. Young boy who was told that he's got a job. You see, these are all scams that go on. He kept receiving emails that he has been appointed as a airline employee in Qatar. Somebody was sending him emails. Somebody told him that you are now appointed, your personality is great, this, that, you qualify as an airline crew. Come for an interview to Qatar. Now this boy was elated. He decided that I will apply for the job. Everything email, it was a complete scam. He sent his CV, he got an appointment letter, so on and so forth. They said, meet our executive. Somebody meets him in uniform in Mumbai. Hands him over a bag and says, this is like just the introduction of what you're going through. Don't look at it now. It's a surprise for you. You open this particular bag at Qatar when you land, when somebody receives you. This is like your identification. The bag had all the identifications on it as Qatar Airways, flight crew, so on and so forth. He was elated. He goes to the airport. In the security system, when he was going through the security check, the security stopped him. They asked him whose bag is it. He says, yeah, it's mine. I'm going to Qatar Airways. And from there, what is recovered is 3 kilos of charas. Now, you see, you can imagine the man's world crashing. And the moment those recoveries were made, obviously he was arrested. Charge has been framed. None of the matter is going on for trial. Now, this is a matter where the reason why I chose this one is because the officers of the CISF at the airport, the Central Industrial Security Force, who man all our airports and shipping ports, they are officers who are not empowered under the NDPS Act to place an arrest. They do not have powers to file charge sheet. They have no powers to arrest. Their job is only prevention. They may apprehend you, prevent that particular incident from happening, and then they have to hand you over to the law enforcement agencies. Now, therefore, when he was at the security check and when the bag was passing through the X-ray machine, obviously you all know that we collect the bags at the end when the bag comes out at the end of the conveyor belt. The officer who was at the X-ray, there are about 4 of them who work in it as a team at the airport. One will be at the place where you put in the bags. The other will be manning the X-ray. And the third will be the person at the other end who keeps watching you as which bags you take. Most importantly, that entire area is covered with CCTV footage. But very important is this. Though the man was apprehended by the CISF, nobody saw him putting the bag on the conveyor belt. You see, they examined 3 officers of the CISF who was there at the airport. The first one said, I was at the input. They term the term when the person who is watching the passengers putting the bag is input. The person who is at the other side is output. And there is somebody in the center who watches the X-rays. But all 3 of them did not depose about the fact that they saw me putting that bag on the X-ray belt. First one came and said, I was standing at the output. I was watching the passengers. When the guy at the X-ray saw some images on the X-ray machine, He asked the person at the output to take that bag and put it at the side. Then after some time, when passengers started coming at the output, we asked whose bag is this? And this boy claimed that particular bag. Now, the crucial question here is this. All three officers who were standing there, who apprehended me, whose entire case, you see, the case of the entire prosecution, their legs, their pivot is the fact that I was the person who was in possession of the bag. But the bag was not recovered from my possession. Now, in a case like this, you see, what could your defense be? You see, if one of these three officers came and said that I saw this particular person, he put this handbag on the stroller, he went through the X-ray, and then we apprehended him there, that is direct evidence. It was curtains for this boy. No matter how much I cross-examined him, there would be nothing that would come out of it. Now, in a situation like this, I would not try and cross-examine that particular witness on the point of identification. Why? Because these are trained officers. They know how to identify people. They know on the basis of facial expressions, he would have given me a complete description of what he saw the boy on that particular point of time and nailed me in the court by identifying this particular person who was sitting in the box to be the same. Fortunately for him, none of them said that I was the one who put the bag. All of them said that we did not know to whom this bag belonged till it reached the center of the X-ray machine. Now, the moment we reached the center of the X-ray machine, that is the time when our suspicion was raised and we said that there's something in this particular bag which we need to check. And at that particular point of time, we gave the bag to the security person who was standing at the output. He asked whose bag it is. Now, in a case like this, I did not ask him anything in respect of the procedure. Fortunately for me, they did not collect the CCTV footage. When all three of them said that we were at our post, there was a crowd at the airport, and we were simply trying to man the crowd to get them in order. And nobody deposed about the fact that he actually had physical possession of the bag. That was a very material flaw in the case of the prosecution. And therefore, no questions were asked to this particular witness in respect of the fact that whose bag it was, what was the first time that you saw it. All that I asked them was, the first time that you suspected that this bag contained something was when it was in the X-ray machine. He said yes. Now, the person who's in the X-ray machine is obviously not looking either at the input or at the output. He is concentrating only on the X-ray machine. So as far as I was concerned, the main witness who was there was the person who was at the input. He was the only person who could have said that, yes, this bag was in my hand and he put it on the conveyor and then it went through the X-ray. So out of the three witnesses who they examined, two of them I had decided that as far as these two are concerned, I'm not going to ask them anything in view of the fact that they obviously could not have deposed to the fact that they saw me. There was only that one witness who was at the input, who at some point of time could have said that, yes, I was in possession of that particular bag. Now, he did not say that. So therefore, in a case like this, you see, it is very touch and go. All that you need to understand is that in this particular case, had I asked that one particular witness, this bag was never with the accused person, he would have said, no, of course it was with him. You see, so in most of these matters which are at the airport and there is an attempt to export, most of the people who are caught at the airport are those persons who are either carriers, whatever terms that you may use, they are promised some money. But these are two genuine cases where both these boys who were about 19, 20 years old had no knowledge about the fact about what they are carrying. And luckily for them both, you see, as I said, because of the fact that they were innocent, I think these flaws which came in the evidence of the prosecution was something which was destiny for these two boys so that they could ultimately, gain their freedom. Now, the charge in respect of both these cases is import and export, right? As far as the first matter was concerned, he was importing it. As far as he is concerned, he was exporting it. Now, the charge that would be in respect of both these cases is possession and attempt to import and export. Now, because it was a psychotropic substance, as far as the first case is concerned, it would be 22. Cheras, as far as the second case is concerned, is 20. And both were commercial quantities. So it is C as far as the Act is concerned, 20C and 22C along read with 29 and 23 of the NDPS Act. So the reason why I discuss these two matters today with you is this. Firstly, both these boys were innocent. During the course of the trial, had I tried to show some smartness by trying to cross-examine a particular witness just to show the gallery that I am going to ask a few questions to impress my client, most of the time it is curtains for the client. In matters like this, one question either makes or breaks the case. So the reason why I point out these two matters is that the officers had not deposed to the T. They had not deposed on this very one vital material aspect, that the bag was in his hand. In the first case, yes, they apprehended him with the bag in his possession, but then they relied on the tags. But in the second case, because he was at the security counter and he did not have physical possession, they relied on the fact that the image in the X-ray somewhere down the line matches with the bag which is before the court. But that was not the question that the court was called upon to adjudicate. The question was whether I was the owner of the bag. Now, fortunately, because this bag was given to me by this rogue who gave it to me outside, there was no personal belonging in that particular bag to show that it connected me with that particular bag. Otherwise, normally we have things like photographs, we have things like, personal items. So there was a matter, I'll tell you, where there was a pair of slippers that were recovered from that particular bag. The judge asked the accused person in open court, wear this slipper and does it fit you? If it did fit the judge, so it did fit the accused person, so he was convicted for 20 years. At that point of time, I'm talking about his Honor Judge Pocha, as he then was in the year 1996. But these are the things that the courts look at, you see. So as far as these two matters are concerned, what was very important for me and the prosecution, if I look at it from the prosecution side, you see what happens is most of the time the officers are not prepared in the court. And if they are prepared, they are over prepared, then they will go out of their way to depose in minute detail, which is also good as a lawyer because you have that ample scope to cross-examine him at that particular point of time. But both these matters, as far as the second case of Shahbaz is concerned, only on this one line, the entire case stands as to whether I was the person who was in connection with the bag or not. Now, as far as the NDPS Act is concerned, there is a chain that needs to be established between the recovery, the seizure, and the CA report. You see, if the contraband is sent to the chemical analysis, the law is settled at this particular point of time that the analysis, which is ultimately done by the CA, the sample that has been sent to them should match with the sample that is prepared during the course of the Panchnama. Now, as far as the forensics is concerned, I believe ma'am will take you all through that. So as of today, if there are any questions on respect of what I've spoken, I think we've run out of time. So if there's anything.
So I'll just take a couple of minutes and explain the forensics application in the case that you spoke of.
Sure.
Just mic. So you can mute your mic. So there's no.
I'll mute.
So as far as the forensics is concerned, in any kind of NDPS case, there are actually, it's quite a limited role that we play. In terms of our contribution, there are two questions that we have to essentially answer as the CA. So I was just talking about the forensics and the CA. One is that we get representative samples. We never get the whole sample that has been confiscated or seized rather at the airport. For instance, in this particular case where 3.9 kilograms was seized, we won't get the entire sample. We will get a small quantity, which is a representative sample. The remaining part of the sample will remain with the investigating agency. So when that sample comes to the forensic laboratory, what is the question that is being asked? One is, what is that sample? And is it the same as the bulk quantity? Because here we're looking at punishment based upon quantities. So it is critical for us to make sure that the bulk quantity is exactly the same as the representative sample. So identification of the drug or the substance in question. To do this, we usually apply some chemical tests, and during the course of the program, we will talk to you about the chemical tests that are used. Now, this particular level of analysis is a qualitative analysis where we're just looking at what is the substance that is in question. And if it is the same substance, that is the part of the bulk or the full seized quantity. The second question that forensics will answer is the amount of substance that was picked up. And in that sense, it is a question of determining quantity to establish that this is the punishment that should be given as far as quantity is concerned. Okay. Now, the science behind these tests is simple. It's mostly chemical tests, and they involve color reactions. We will be talking about one of them just now as it applies to this particular case that Sir was talking about, the tennis player. The instruments that are used to get the accurate quantitation, because there are certain instruments used that would be the chemical process involved in identifying and quantifying what the sample is. So we'll talk a little bit about that in terms of the program at a later stage when we get to the stage of forensics interweaving. And finally, the comparison of that particular unknown substance. We'll call it unknown because at this point, we don't know, it's been seized. You have a tentative ID, you will run it through controls or standard databases to establish the authenticity of the identity. So this is the scientific process that backs up and is produced as CA reports that will support the identification and quantification of the seized material. Now, in this particular case, sorry, I'll just go back. In the case of the Lalrin Puya case, we're looking at 3.9 kilograms of an off-white crystalline powder being seized. Now that off-white crystalline powder, as far as, like Sir said, the officers are well versed, but they're also equipped with some scientific material in the form of a drug testing kit. And the drug testing kit is something that is available with them at the point of seizure. They can then do quick screening tests to establish what the putative identity is. Again, we're not certain. We're doing this as a screening tool at the time of seizure. Then there will be an entire process of creating a representative sample and moving that representative sample in a legal fashion to the lab for proper analysis. So this is just a quick screening tool that is done at the airport. It's very easy to execute. It's basically a chemical test. It's extremely sensitive. So the quantities that are required are very small. So there's no question of tampering with the evidence or destroying evidence because it's a few grains. And finally, the results are also easily tested because these kits are made readily available. So like commercially available kits. In this particular case, for methaqualone, the standard operating procedure is to use a test called cobalt thiocyanate. Now, this is basically a reagent or a chemical that is added to a few grains in a test tube. The chemicals are mixed together and you get a color change. And the color change would be represented as blue in this particular case. Simultaneously, you're testing possible other white crystalline powders, which would also possibly give you a blue result. And as you can see in this particular test, this cobalt thiocyanate is giving blue for lots of substances. So at this point, the officer would not know which substance it is. He has an entire menu card, but he can apply a second test, which is the Fisher-Morris test, slightly more complicated, but again, doable at the scene. And once those results are provided, you see that the possibilities are now narrowing down. So if we look at cobalt thiocyanate test, you have 8 possibilities. But when I couple it with the Fisher-Morris test, and it's just a combination of more chemicals added to that few grains of powder, and then a layer of chloroform added, we're getting no color and yellow. What does this mean? That when you make that mixture and you shake it up, it partitions into 2 layers, an upper layer and a second and a lower layer, because water and chloroform don't mix. It's like an oil pani mix. And the colors of the 2 layers will change because of the drug that was added in. So when you look at methaqualone, you're looking at the water layer having no color, the chloroform layer having a yellow color. And if now we look down the entire chart, we don't see this combination except for methaqualone and mecaqualone, which are, it's the same family of drug. So now you're pretty certain that this could potentially be the white substance that was recovered. And now it will go to a CA's lab for analysis and further confirmation. And then the official reports will be provided. So do you want to add anything to this in terms of the chart sheet and what you will see? As in the chart sheet, from my understanding, it's only reported as drug tests were done at the time of seizure. Is that correct?
Yeah. Yes, you're right. See, most of the times when the seizures are made, central investigating agencies are equipped with these drug identification kits, and so are the narcotics cell and the state agencies. But there are a number of times where these contraband are mixtures. You see, you may have cocaine, you may have heroin mixed, you may have alprazolam, diazepam mixed. So these tests are preliminary tests. You see, they are sometimes at times misleading. And therefore, we have the laboratories which are constituted under the government, and those reports are admissible under 293, which are the final reports. Until Hira Singh came into the picture, the latest judgment of the Supreme Court, where it says that the entire quantity should be considered and the entire mixture should be considered. If you see entry 239 to the Ndps Act, even prior to Hira Singh, there were certain criteria in respect of how mixtures need to be analyzed and what would be the weight per se in respect of sentencing if you want to quantify the contraband as commercial quantity or not. So ultimately, of course, what prevails in the court is the CA report. Under the Ndps Act, it being a special statute, case laws now say that examining the CA is a must. You cannot just exhibit the CA report and not prove its contents. The reason being that the accused person have an effective right to cross-examine, and the expert is also susceptible to mistakes. Your equipments may not be up to the mark, so on and so forth. And therefore, at this particular point of time, as the law prevails, the examination of the CA is necessary. We'll come to that aspect at some other point of time. Any questions today from anybody? I'd be happy to answer.
Ma'am, are we done with your presentation as well?
We can talk a little bit about the course and what we intend to do in the program, if this is the time, unless maybe people want to ask questions, and then we can address the contents of the program. For 5 minutes.
Sure. Let's take questions first. Guys, if anyone has questions, just raise your hand, or you can put it across to me on chat. I have received 2 questions as of now, and Tandon saab ka ek question hai. I'll give him the mic. And otherwise, those who don't have questions, just let us know your feedback. How did you like the session? How did you like, what Sir talked about? Personally, I saw, everyone on the screen, hooked to the screen for the time that Sir was speaking. And a couple of things are very clear, when we listen to Sir. Ki, fortunately or unfortunately, there are a lot of cases on NDPS in the market. And secondly, people are totally uninformed what to do. And not only the clients, but also the lawyers. And, when we learn about these new subjects, we come to know there is more than matrimonial and CrPC and all that. And we should, as lawyers, try to learn all these things. And thirdly, that ma'am and sir se अच्छे trainers नहीं मिलेंगे इसके लिए. Such experience and such knowledgeable, teachers and trainers, I don't think we'll get them anywhere. So these couple of things, I think I am very sure about these. You tell us in the chat, and Tandon sir, मैं आपको mic दे रहा हूँ. You can ask your question.
Good evening, sir. Am I audible, sir?
Yes, sir. Mr. Rajesh, I can hear you clearly.
Sir, thank you very much, sir. It was an extremely interesting lecture, and it will be a pleasure to attend your classes. It was something like, movie thriller that we all were hooked on to your description of the cases. Now, the second case which you had discussed, sir, in which you said I only examined that fellow who was on the responsible for the input, not the person who was looking at the X-ray machine and the output. But you said, they didn't depose it. I somehow did not got the hang of it. Didn't you examine the other two, cross-examine the other two? I mean, X-ray people and this thing.
No, what I was pointing out is this. The persons who was at the input was the only person who could have seen the person with the bag. The person at the output was handling the passengers who had already cleared the check-in. The security. The person at the X-ray would be concentrating only on the monitor. And the person at the input, he is the person who is visible to the passengers who are in line for the purpose of going through the, you've seen the airport, how chaotic it is. And especially, as we the line mein khade rehna is not our forte. Everybody wants to jump the queue. Some people want to put the bag over somebody else. And you see at the airport, bags, belts nikalo, jute nikalo, at some airports you'll be made to remove, all these things and put in trays, so on and so forth. So it's always very chaotic at the input. It may not be so much at the output because you just pick up your bag and go. But at the input, that particular person is very, concerned about the fact that what you are doing. Now, that person's evidence was very vital to show that this bag belonged to me. Now, through oversight, or genuinely, he may not have seen me putting that bag in view of the fact that I just put that particular bag and went and stood in line without any chaos that I caused at that particular point of time. You see at the airport, you always have those one categories passengers who will keep complaining. Arey line mein aana chahiye, ye dekho line tod raha hai. Or you'll have that one particular person who wants to argue with the security person. Arey main kyun belt kyun nikalu, juta kyun nikalu. You see, those are the persons who that security person remembers them. If you are at the airport, you see thousands of people, right? Imagine yourself manning that input counter. आप दिन में कितने लोगों को देखने वाले सर? Hundreds of them. But you will remember only one or two if he acts funny with you. आपको बोलेगा मैं बेल्ट नहीं डालूंगा, मैं क्यों डालूं? तो आपको वो आदमी दिमाग में रहता है. But जो दूसरा regularly जाता है, he's not going to remember you. So had this person deposed, I'm sorry, I can't hear you. Your mic is off.
I said, sir, I generally got the hang of it. Maybe I should have put my question better. Should I take it that you examined only input chap and purposely did not examine the other two so that they will, otherwise they will spoil you again. And you took advantage of that in their deposition. They did not by themselves say that we have not seen this guy. And the question which was asked from the input chap, you took advantage of in your summing up. Should I say this?
No, I am for the accused. I am not for the prosecution. This, what you just asked me, was the prosecution's job. The prosecutor should have applied his mind to the exact question that you put to him.
No. As a defense lawyer,
yes.
I take it that you did not, you asked only to the input chap. Did you see this
No, I did not ask him anything. Achha. That is what I was saying. That had I asked him, he would have said, no, this bag belongs to him.
So you did not, you took advantage of that,
yes.
that it did not come out in their deposition that
yes.
They, either of them had seen this boy taking the bag.
Yes, yes.
Thank you very much. And my next question is to ma'am. Ma'am, you're talking of that job which is there for forensic, chemical analyzer. Whether the sample which has come to you, representative sample, resembles matches with the bulk sample. So how do we know that this is matching with the bulk sample? You have given
good question. Sir will be
representative sample. You have given analyst.
Sir will be addressing that. Yeah,
I'll tell you.
Sir, you're muted. Sir, you're muted.
You see, under the Act, it is mandatory for the officers to describe the characteristics of the contraband that is recovered at the spot. Now, if it's powder, for example, it could be in powdery form, it could be in coarse form, it could be crystalline, it could be white in color, it could be brown in color. You see, so those physical characteristics of the powder are already described during the course of the Panchnama. Now, if, for example, in the Panchnama, you mention it brown color, in the color of the powder, which is coarse in nature. And what has gone to the CA is white color, which is crystalline in nature. So there's a marked difference between the two. So therefore, it assumes importance of what is described in the Panchnama and what is sent to the CA. If it does not match perfectly, then you have a case to argue that what has been sent to the CA is not what is sealed at the spot.
That you can only...
So please correct me. So
Yeah.
just to add to that, I think Sir will also take this up later, is that there is a particular process in which the sampling is done and it's very thoroughly documented. Each packet is numbered and quantities are removed, the amount is weighed. There is a process as far as procedure is concerned, which Sir will get into. Is that correct? When we do the NDPS Act, which is also something that helps in the documentation helps create the link.
So we have a standing order under the NDPS Act, 1/88 and 1/89.
But the report of chemical analyzer, can it qualify for that? Yes, it matches with the bulk sample, because bulk sample has not been sent to the...
I agree with you there. I mean, there was a misslip there. It is not the bulk that is sent. But what happens is that until Mohanlal came into the picture, the bulk was also produced in the court. So the bulk, the sample, and the CA, they had to match. It had to be a triangle. You see, a bulk comes which is brown in color, sample comes which is white in color. CA describes it differently. So obviously the bulk and the sample do not match. You see, it is very easy to make false cases as far as the NDPS Act is concerned. There are I would say thousands of cases where people are picked up from home. You have good influence with the police. I mean, I don't want to get into that aspect, but there are cases which are made out. So for example, if you have 10 grams of cocaine, you see, what you need to send a sample of 2 grams. So jo 8 gram ka jo bulk hai, that may not be cocaine. You need 2 grams to send to the CA. So the other half could very well be talcum powder or sugar crushed or chalk powder crushed. You see, so therefore, when it comes for the purpose of an officer making out a case, he is concerned with the CA report coming positive. He may produce the bulk in court, but there have been cases where we have asked the court to send the bulk for retesting. But then it is termed as, okay, you're trying to delay the trial, you want to make frivolous applications. Still, once again, there was a judgment of the Supreme Court which said that you can do retesting only within 15 days of the first CA report coming in if you are aggrieved by its contents. So thereafter, all that stopped. So the bulk, sample, and CA is important for the purpose of proving a charge. And their characteristics also are important.
Has it been an incident which you have ever faced in bulk is a milk mixed kind of sample that you can't segregate?
Oh, there are a number of cases, sir. Because you see, drugs are never sold in the pure form on the streets. They're always adulterated. आप चरस लो तो उसमें बूट पॉलिश मिलेगा, आप कोक लो तो उसमें डायज़ेपाम मिलेगा, आप हेरोइन लो तो उसमें अगरबत्ती ऐश मिलेगा.
That I got it, sir. Supposingly 3/4 type of contraband and
yes, supposing there's a mix. I'll tell you the favorite mix of. आप ताड़ी देखते हैं ना रास्ते में जो मिलती है. शाम में 6 बजे के बाद what you get as ताड़ी and नीरा which sold. Those are mixed normally for that intoxicating effect with a substance known as alprazolam. Earlier on, it was not covered under the Act. Alprazolam was available at the streets. You could get it off the medical stores. You still can on a prescription because it is now covered. But alprazolam is mixed with these toddy for the purpose of giving these effects. So there would be some dealers who would use alprazolam. There would be some who would use diazepam. And there could be a mixture of both also. You see, so for the purposes of, if there is a substance which shows the presence of 2 different substances, for example, then for the purposes of computing commercial quantity, the minimum of that particular substance is taken into consideration. For example, if you see the table under the commercial quantity, cocaine is 100 grams for a commercial quantity, and diazepam, I think, is 500 grams, subject to correction. So, for example, if you have a mixture of cocaine and diazepam, and the CA report shows the presence of both, then the minimum quantity, which is 100 grams, will be taken into consideration for the purpose of converting it into commercial quantity. There is an entry under 239 of the NDPS Act in the table below, which quantifies this particular eventuality, wherein a CA report comes in the form of mixture of two different substances.
Thank you very much, sir. Okay.
Cheers.
Great explanation, sir.
Thank you, Raj. Sir, before moving on to Ayushi, who's been,
there are some questions here which I think are on the chat. And there is one particular one which caught my eye, which says that there is a presumption the moment you check in your bag. So I don't know where is that.
That's right at the top, sir.
And that was by, where is it? Where is it?
Sir, we talked about the question by Utkarsh Bhushan. As soon as I check in my baggage, it will be presumed.
Yeah, that is Bhushan, sir. Who is that? Bhushan?
Mr. Bhushan, are you in the room? Can you raise your hand?
Utkarsh Bhushan.
Yes, sir.
Are you there?
Yes, he is, sir.
Okay, Bhushan, I would just like to clarify this particular aspect of as soon as I check in my baggage, it will be presumed. No, I would disagree with you there. There was one very landmark case which we had conducted before courtroom number 44, before His Honor Judge Kulkarni. Issuing of these baggage tags by the airline is also a process. You see, these tags are issued by the counter. I'll make it as simple as I can. Now, if you've ever been to the airport, I'm sure you have, and you've checked in your bag, there will be instances where one tag is issued and the personnel at the check-in counter will either tear it and throw it because it's a mistake on it. Or, for example, if you put a particular bag of, say, 20 kgs, she has issued a claim tag on the basis of 20 kgs. Thereafter, you put in another bag of 5 kgs. So your weight becomes 25. And you tell her, now, ma'am, I want to put 25 as checked in baggage. So that earlier tag is cancelled. She will issue you a fresh tag of 25 kgs. Now, if you see all these tags are on a roll. At the airport, at the check-in counter, there is a roll. There is a machine which prints out these tags on the moment she punches in your PNR number. Now, at the end of the day, those tags are accounted for, the number of tags that are issued by each counter. Now, who is the author of those baggage tags? Is the airline, the person who is sitting there. Why? Each of them has their own password. For example, if I am at a counter sitting at the airport, I use my password. And then the system allows me access to issue those baggage tags. So if, for example, I am sitting at the counter and my password is 3, and if you sit on the counter, your password is 4, those tags will be attributed to you. They cannot be attributed to me. So the moment a tag is issued, it is on the conveyor belt and it is not in your physical possession. There, in my review, I've been arguing this throughout and it has been found favored by a number of courts. There is no presumption. Presumption, what you are talking about is constructive presumption in view of the fact that you say, no, you still are you are still the owner of the bag in view of the claim tag. Prima facie, yes, what you're saying is right. But in a court of law, you can cross-examine and disprove that. You can disprove the fact that the person who was sitting at the airport who issued that particular tag has to be examined for the purpose of trying to prove the contents of that particular baggage tag. Because that is a document on the basis of which you are trying to prove constructive possession as far as I am concerned on the basis of the claim tag. There are a number of cases where there is only a baggage identification tag and there is no claim tag. People swallow the claim tag. People tear the claim tag and throw it away. Then how do you show that it is presumption when I am not found in any possession of any claim tag? You see, so the case on facts will vary. There will be cases where there is a claim tag which matches. There is a case where there is no claim tag. But as far as those check-in documents is concerned, there is enough material to show, sir, that the person who has printed that particular tag is the author of that tag. And it is incumbent on the prosecution to examine the person who printed that tag and gave it to me. I could not have checked my baggage. For example, if there are two friends traveling, you see, if you see there is a particular system at the airport which is known as group travel. आप tour पे कभी गए हैं या if you're in a group of say 50-20 people traveling together, you have a group check-in. So if you have a group check-in, how can the owners of the bag come to you? You can very well take the defense that, sir, this was a group check-in. This is not my particular bag. So the entire group can't be arrested because of the fact that there is one person who has contraband in his bag. So there are a number of such scenarios that, you know, prevail at the airport, and different cases keep coming up over a period of time. But in most of these checked-in cases that I have conducted, I never admit the fact that this bag is mine. You always deny the fact. Unless, as you see that case of Daisy Angus. This is a very classical case of an Israeli girl who was arrested at the airport. I think she was French. Kindly read that judgment on the basis of possession. It's very informative, and it will help the lawyers and the ones who are interested in the legal field to just go through that. It's, I think, in my opinion, it's one of the classic judgments of the Bombay High Court, which was passed by His Lordship Justice Bhatia, wherein all the aspects of possession and constructive possession, physical possession have been discussed. And it's a case where the lady was arrested at the airport itself. The bag belonged to her. She denied knowledge. She said, this bag belongs to my boyfriend who's traveling with me. Boyfriend said, no, I do not know about it. So what would the court do? Very interesting. Kindly go through that judgment. Daisy Angus versus Union of India, and it is dated the 7th of April, 2007. 2007 ka judgment.
Got it, sir.
Okay.
Right. Sir, should we take the next question?
Yes, sure.
All right. Also, before moving on to the next question, जो लोग आप लोग comments मुझे personally भेज रहे हो, please let sir and ma'am know like you like the lecture. मैं इसके screenshots लेके या तो sir को WhatsApp करूँ. That will be a little difficult for me. So, you know, if you can use the chat box. And Ayushi, coming on to your question now.
Hello, good evening, sir.
Yeah, Ji Ayushi, good evening. I can't hear you though.
Ayushi, you muted yourself.
Hello, am I audible now?
Yep, you are.
Sir, at the output side, when Syed Shahbaz, he actually claimed the bag. Said to be in possession of the bag when he actually claimed it himself?
No, that is the part where you deny. That is the part where you tell he did not claim the bag, because the bag, the moment it was on the belt, is in the possession of the CISM. You see, it's like this. You ask 2 more questions to the bag, to the officer. You see anything incriminating in a bag, you will keep it in your custody. You will not give it to anybody. He is bound to say yes. So when you called Shahbaz, the bag was in your hand, not in the hand of Shahbaz. He is bound to say yes again. I can't hear you.
Chief of the person at the output end, didn't it come in the chief that the person actually claimed it?
No, at the output, he said, we asked whose bag it is.
Okay.
And then his case was that the accused came forward and said, this is my bag. But yes, but the possession was still in the hand of the CISF. It was never in my hand.
Okay. That is tricky.
No, that is an event. That's a matter of fact. And you see, that is what you have to exploit. That I didn't come and ask you for the bag. You came and told me that this is your bag. That is where you take your defense, that this was foisted upon you. Okay. And therefore, the best, you see, in every criminal case, the principle is the best available evidence must be produced. Now, how do you quantify this difference when they saying that this bag is yours and I saying that this bag is not mine? It's a word, right? It's my word against yours. But there is evidence in the form of CCTV. And if you don't produce it, there is a presumption that it was against you because there is evidence available and you did not produce it. Therefore, you choose this line of defense.
Sir, and when does that presumption that you said initially, that the presumption when in possession lies on the accused, when does it come into play?
Oh, immediately. If it is found in your possession, 35, 54, 114 Evidence Act, they all come into play. And the law presumes you had knowledge. You see, possession you may deny. See, possession is of 2 forms in these kind of cases. First is that if you are found in possession and you deny knowledge, there is a presumption. But if you're not found in possession, there is no presumption. And on the facts of the case, it could be either be physical or constructive.
Okay. So that is little. Oh, fine.
No,
Sir, and
I'll be more than happy to answer. What was little?
No, actually, that is, we were told in the previous course of POCSO that even if the presumption lies on you, the prosecution still has to prove the case beyond reasonable doubt.
Agreed. Presumption kicks in only after possession, but I'm talking prima facie. See, there are two stages. One is pre-trial stage, and one is post the charge being framed and the evidence being recorded. It depends on the defense that you take. You see, I mean, there is a school of thought and there are a number of lawyers. Of course, we always have this difference of opinion of what is the line of defense that one should take. You see, this case of Daisy Angus that I've just asked you to read, this was a case where the line of defense was that, yes, I am found in possession. I am not denying recovery. Bag is mine. Charas was recovered from it. But I had no knowledge about the fact that there was charas in it. That was her defense during the trial. You read that judgment, very nice judgment it is. So when she said that I admit possession and recovery, half the job of the prosecution is over. They don't need to prove the panchnama. They don't need to prove recovery at all. Why? Because you have admitted recovery. So if you admit recovery and you deny knowledge, then the onus is on you to rebut that presumption. How do you do it? By examining yourself as a witness. Or you examine a witness. For example, there are 3 of us here in this room, right? So I could give a bag to my junior here and say, go and give it to somebody. He's caught at the airport. How does he rebut that presumption? He says, sir, give me that bag. And there is a witness here in the form of Riva Pocha who sees it. So he first examines himself, then he examines her. Then she deposes to the fact that no, Advait was somebody who just carried the bag. Sir had given him the bag. Okay. And therefore, he admits the possession. He says, yes, the bag was recovered from me, but he gave it to me. And I have a witness to prove it. That is how you prove a rebut in the presumption. That is only if you admit the possession. You see, if there is no possession, there is no presumption. You understand?
Sir, if you see section 37, it is, even though it is a non-obstante clause, there is an exception to it which states that if the prima facie case is in the favor of the accused. So I think that even if the prima facie case is in the favor of the accused, this presumption is what prevents people.
No, 37 does not say that. 37 says that if it is commercial quantity, no bail should be granted. If it is offense 19, 25A, commercial quantity. There are 3 criteria. And the non-obstant clause is that it is, if you see 37, it also says that unless the court comes to the conclusion that he is not guilty of that particular offense. There are 2 clauses as far as 37 is concerned. 37 is not concerned with presumption at all. For under the Act, if you're reading presumption, read 35, 34, and read it with 102 onwards of the Evidence Act. Go through 101, 102 till 114 of the Evidence Act. Okay. You read these 3 in conjunction. You see, if you read these 3 sections, they are all on presumption.
And sir, I did not understand in the Hira Singh's case, they actually replaced the representative quantity with the entire quantity. What does that mean?
I'll tell you. See, there was a judgment, E. Michael Raj. You just Google that judgment, E. Michael Raj, in which the Supreme Court had held that it is only the pure drug content that should be considered for the purposes of convicting a particular person. So there were a number of CA reports which came in which showed the actual percentage of the drug content. For example, you sent the sample to her analysis to the laboratory, they would say sample analyzed, 20% of cocaine has been detected. That means 80% is not cocaine, it is impurity. So if you're found with say 10 grams of cocaine and 20 grams is the CA, 20% is the CA report, Supreme Court held that you could be convicted only for possession of 2 grams. So therefore, there was a notification that came into effect in the year 2011, I think, subject to correction, which said that the entire quantity should be taken into consideration. Couple notification, 11 के 9. Okay. So then that notification came into consideration, and then the judgment of the Supreme Court in E. Michael Raj was referred to a larger bench in Hira Singh. And in Hira Singh, the Supreme Court said, no, the entire quantity of the drug should be considered for the purposes of convicting a person or analyzing whether it is commercial quantity or not.
Okay, so which means that different standards for seizing the representative quantity per set.
No, it means that supposing there is 20 grams of cocaine and 80 grams of flour, which is a neutral substance. You see, most of the people with drugs which are sold on the street are mixed, you see, for the purpose of enhancing the profit of the peddlers. 5 gram pure cocaine, un log 15 gram bana dete hain. Correct? By adding impurities. Supreme Court says you take the entire quantity into consideration. Why? Because you are selling it as 15 grams. You are making money which is 15 grams. So why should you be convicted only for a lesser amount of the 20%? So that is the principle in Hira Singh's case.
सर ऐसे तो जो क्वांटिटी कलेक्ट की जाएगी उसको बहुत डिस्प्यूट कर सकते हैं कि ये
नहीं, आप भी पहले कर सकते थे, अभी नहीं कर सकते. आपने हीरा सिंह के पिक्चर पहले हम लोग बहुत करते थे कोर्ट में. We would ask we cross-examine the CA at length. What were the impurities? Why didn't you conduct the other tests? All that we would ask. But now with Hira Singh, till it is overturned, it is I think being referred to a larger bench for reconsideration.
अच्छा सर, ई कोर्ट्स के लिंक मिल सकती है क्या? ई कोर्ट का जो ऐप है, बिकॉज इवन आई एम लोकेटेड इन महाराष्ट्र, तो सो दैट आई कैन रीड योर एविडेंस कि आपने क्या क्वेश्चन पूछे थे.
बट अपन एविडेंस नहीं आता है उस पे.
सर आता है,
एविडेंस आता है. Okay, I will give you the case numbers. What you do is I'll give the case numbers to Riva. You take it from them, so you can read the evidence. No problem.
Okay, sir. Thank you so much.
Okay, thank you so much, sir. I think we've already consumed the time that we had, asked from you. Though we have questions still left to be answered, if you allow.
Yeah, it's okay. Tell me. I'm enjoying myself.
Okay, Rajesh ji, I'm giving you the mic again.
So one doubt after what Ayushi asked the question. Now, should we take it the entire sample will go for the chemical analysis?
No. The sample will be separate. Bulk is separate. But वो sample में ही analysis हो जाता है सर कि इसमें कितना percentage of drug है. Sample goes of either 2 grams or 5 grams only. But when the report comes, the CA will say, sir, इसमें 20% cocaine है.
They got it, because a few minutes before when the Hira Singh case was being discussed, you said the entire thing will go. No, that is the
yes. What I meant was then the entire bulk will be considered. If I'll give you an example, you are caught with 10 grams of cocaine. Okay, it is non-commercial quantity. Cocaine ka small quantity is 2 grams. It makes a lot of difference in the sentencing structure. 2 ग्राम के लिए आपको 1 साल की सजा हो सकती है. 10 ग्राम के लिए आपको 10 साल की सजा हो सकती है. तो आपने लिया 1 ग्राम कोकेन. Supposing you buy 1 gram cocaine and you want to make it into 10 grams to sell. ठीक है, 1 ग्राम आपने लिया, आपने 9 ग्राम उसमें आटा डाले और बाकी का आप बेचने लगे 10 ग्राम. करेक्ट. सैंपल 2 ग्राम का बनाएगा ऑफिसर, and if the sample goes for analysis, CA report will say, sir, cocaine 10% detected in this sample. क्योंकि आपने 1 का 10 करे थे, वो हिसाब से आप you can be convicted only for 1 gram if you go by E. Michael Raj. Because E. Michael Raj said you can be convicted only for the drug content, pure drug content. But Hira Singh says no, 1% नहीं, आप तो 10 ग्राम बेच रहे थे. तो अब ये पूरा quantity will be taken into consideration and you will be charged for 10 grams, not 1 gram.
Rest of the bulk will be kept there only.
Yes. It is produced in court as evidence.
Right. Thank you, sir.
Thank you, sir. Sir, one last question I received on WhatsApp. This is a little general question. So, in many cases like POXO and NDPS, accused persons, they have to languish in jail because of the presumptions that these legislations provide. So, as a lawyer, what can we do to help our clients not languish in jail under trial?
Baba. To that, there is only one answer: get more judges, get more trial courts. The law is enacted for a purpose. You see, most of these guys are heinous. These crimes are heinous, whether you may agree or disagree. As a lawyer, in court, it's different. But otherwise, I would like to see them behind bars for the rest of their lives. Let me be honest. You see, court, when you defend them, you are, being loyal to your brief is a different aspect altogether. But Pocha, I mean, what is the nature of that crime? You catch kids and, do all that. Let him bloody rot in jail. Absolutely no issues on that count. But yes, if you talk as a lawyer, we should, because of the fact that Constitution talks and Supreme Court says right to just speedy trial, so on and so forth. What else can you do? Let those presumptions remain. Because in these kind of cases, evidence is sometimes difficult to bring forth before a court of law and make it admissible in evidence. Because anything said to the police in today's times is inadmissible. So you see, when everything what is collected by the police is inadmissible, say when except 27. So the legislature obviously in its wisdom feels that there should be something that should be available to the prosecution to prove its case. नहीं तो कैसा होगा? अभी छोटे बच्चे, for example, in Pocha, they don't even know the nature of what is the crime that is being committed on them. You see, so I mean, the accused person in these kind of cases, where they can, easily influence these witnesses or they do not know the nature of the crime, there ought to be these presumptions. I don't feel that these presumptions are anything against the law. Why? They are rebuttable presumption. You see, you have an opportunity to rebut these presumptions. It's not that a presumption hai, that is the end of the matter. You don't have a defense. No. Which you can exercise. I mean, you use your head and during the course of the trial, decide the right cause for you. You see, how to rebut it is, of course, everybody would, when you ask 10 lawyers, they'll give you 10 different opinions on how to rebut it. But there is a rebut. The presumption is never conclusive. Remember that. Right. It is always rebuttable. And you rebut it by leading evidence. As the prosecution has a right to lead evidence and prove its charge, you have a right to lead evidence and rebut the presumption.
Right, sir.
So I think it's fair and square there.
Right, sir. All right. I think we have done all the questions that we had, sir. Thank you so much for answering these so amazingly. And thank you so much, Riva ma'am. And, I think I had already read the comments that people had shared in the chat. I would just add one more thing, that I've grown, more grateful to Riva ma'am ever so, because of, ma'am ki itni contribution hai LCI pe, first the Evidence Act course, then the Pocha course, and now we have Taraq sir on the platform. And I think it's going to be amazing. And it's not just NDPS that we are going to learn. Aaj mein humne references dekh liye, Evidence Act ke, then there is CrPC, then we, everything, cross-examination, learned a lot about tags, airports, I don't know what all. So it's going to be awesome. And jitne log is meeting mein hai, I hope to see every one of you in the classes. And is there anything that we need to add, ma'am, before we wrap it up?
No, Raghav. I think that's that. We've already got everything uploaded on the website. So the syllabus, the way it's going to be laid out, how it's going to be taught is already shared if you get onto the LCI website. Right.
So just informing you all once again that it's going to be 24th May that we're going to start with the course. These judgments, some people have asked, Hira Singh, Mohanlal, E. Michael Raj, Agnes, Daisy Agnes, all these I've noted. You'll get these in 1 or 2 days. And you'll get the recordings as well on YouTube only for this lecture. आगे के जितने lectures हैं, उसके लिए obviously you'll have to join the NDPS course, which will start from 24th May. Once again, thank you so much, Taraq sir. Thank you so much, Riva ma'am. Oh, you muted, sir. And ma'am.
Thank you so much, everybody. Thank you for your time. And it was really wonderful interacting with you guys.
Have a great evening.
Thank you.